Removal proceedings, part 5. We are back again. Remember, we said that we're going to be talking about removal proceedings, strategies, defenses, bond hearings, you name them. Everything removal proceedings related. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex US immigration law cases every day. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. In terms of this video, I'm gonna answer a couple questions. Okay, there's a person who actually called me 2 days ago. They're in removal proceedings. Removal proceedings, by that we mean if you have been order removed, you are in removal proceedings. If the case is pending, you are in removal proceedings. Pending with immigration court, pending with BIA, previous order of removal, you are still in removal proceedings. As long as the case has never been dismissed or terminated and you have order of removal or any of the likes, you are still in removal proceedings, even though you don't have court hearing. The simple fact that case was heard before, not terminated, removal proceedings. Okay, so a person calls me and says, I am going to I want to reopen my case. I'm in removal proceedings and I'm going to reopen my case. Let's talk about it. Motion to reopen. When exactly should I file a motion to reopen? The law says that within 90 days, you can file a motion to reopen your case if you have new evidence that was not discovered at the time of filings and it was not easily discoverable at the time of filing or at the time the decision was made, and those new evidence just came to light and you want to reopen the case. Some people, sometimes, a lot of people will try to say, well, now I have a I-130 petition approved. Should I reopen the case because this is new evidence? That does not really meet the standard when we're talking about new evidence, okay? Because otherwise everybody will say, well, my I-130 petition just got approved. Should I reopen based on new evidence? No, that's not how new evidence come into play, okay? The reason you got I-130 petition approved, maybe now your child is 21. By the time you went to the hearing, the child was perhaps 10 or 12. So now the child is 21. This is not new evidence. This is basically the way they're going to look at it is the fact that the person did not claim adjustment of status at the time of the pleadings. Now they have a better defense, but after the facts, after being ordered removed, we don't do new evidence based on that. New evidence come into play when, let's say, for example, you apply for asylum and now you said that I was tortured, I was this, I was that, but you couldn't really prove it, right? Or you couldn't get those evidence. But after the facts, the evidence of torture came into maybe your country released those documentation, maybe because of new president, they're releasing documentation on how people were tortured and you were among those people. Those are new evidence. Was not easily discovered back then. You couldn't get those evidence. Now you have them. Now you can reopen the case. That's just a simple example of reopening after 90 days or within 90 days when new evidence is come into play, okay? Well, if the 90 days has passed, can I still reopen my case? You can reopen it if you file a joint motion, okay? Under this current administration, more likely they're gonna deny it, but can you try on your own? Yes. Am I trying those new motion to reopen jointly with ICE. Right now, I'm not taking those because of just the likelihood of not being able to succeed. Okay, it's very high. But let's say you want to reopen your case based on change in country conditions. What are those type of changes? This is in the context of asylum. Okay. Well, if there's a political coup, there's a new civil war that just broke, there's something of major importance that just happened now as we speak in your country that's closely related as to why you cannot go back, we can file, reopen the case based on change country conditions. But remember, if the problem you were denied before was based on credibility, we still have to come back and rehabilitate your credibility, restore it. Otherwise, it can be reopened, but it's not gonna work. Okay. Well, you wanna file based on new evidence again. New evidence wasn't easily discoverable. It's new, and I already gave the example. Another way people reopen after 90 days based on ineffective assistance of counsel, but this one to the standards very high. You have to prove, first of all, that you had an agreement, what the agreement said. You gave the lawyer the opportunity to defend themselves, and you let them know that they failed you in court, and you have to give them the opportunity to defend themselves. And then, because of their ineffective assistance for counsel, that's why your case got denied. So you have to be able to prove those three elements procedurally to win on that motion to reopen based on ineffective assistance of counsel. But remember that in the Fourth Circuit, where we are here, Maryland, Virginia, DC, you don't really have to prove that you told, even if you tell the lawyer and the lawyer didn't respond, that's not really a big deal. But still, you have to show what was the contract in question and what exactly the lawyer failed to do that led to a denial. Okay. They're a little bit not too strict when it comes to proving those three elements. Okay, in the Fourth Circuit, that's something to keep in mind. And the person can reopen their case sua sponte. This one is very hard, right? Sua sponte, you reopen after years. You can reopen sua sponte if there are, how do I say, the standard is very high, right? Exceptional circumstances, that's the word I was looking for. You have to show, exceptional circumstances. And a clear example will be, let's say the person wants to get a green card because they have cancer. Okay, they have cancer. The only way they can get treatment is if they are legally present in the United States. In terms of legal status, right? Now you can file a motion to reopen if you have I-130 approved, and you say, well, I want this case to be reopened because I have I-130 approved, visa is immediately available, and now that I have cancer, I really have, can you reopen it sua sponte, because those are under exceptional circumstances beyond my control. I really have to get medical care. This might work sua sponte. Okay, to recap, can you file a motion to reopen? The answer is yes. You can file within 90 days. Okay, showing new evidence that was not available and now available. Because it's within 90 days, the standard is very low, but just know that it's your one chance to file within the deadline. You really have to have strong evidence to convince that those are new evidence, wasn't available and wasn't easily discoverable. That's why I want this case to be reopened. Okay, within 90 days, it's within the time frame, that's fine. Okay, after you pass 90 days, can you file a motion to reopen? 5 ways. Joint motion with ICE. If ICE agree, that's really easy. We've done it a lot under Biden. ICE agree, easy. Judge is more likely to agree. And then you reopen your case. I-130 is already approved. Then you adjust your status. Okay. Number two, after the deadline, you can file based on ineffective assistance of counsel, but you have to prove three elements. The standard is very high. The agreement that you made, what they're supposed to do, did you contact them, what was their response, and because of what they failed to do, that's why you got a denial. You have to be able to prove it in order for the judge to reopen your case based on ineffective assistance of counsel. New evidence. New evidence must be new, of course, wasn't easily discoverable, was not available, not easily discoverable, and really new in terms of reopening the case. Change in country conditions, something really major just happened related to my asylum, and now I have to reopen the case. We give an example of coup, political coup, change of political regime. Those are big example. Not to mention that it has to be related to your asylum. And if previously they find that you lack credibility, just know that you have to rehabilitate yourself first, all right? And then lastly, sua sponte, you have to show exceptional circumstances beyond your control. A clear example will be a disease. Those type of major type of disease that just came and you can't really get medical treatment if you don't have a green card, okay? But still you have to have the basis for a green card, right? I want to reapprove immediate family member, those type of things. That's about motion to reopen. And what I wanted to add about this topic is the fact that sometimes the person's filing for an appeal, but they want to submit their appeal and they have new evidence, not easily discoverable, new, wasn't available at the time of trial. The moment they submit new evidence, what's going to happen is that it is going to be deemed as a motion to remand. They're going to remand the case back to immigration court. But you still want to file appeal because you want to stay removal order. You just don't want to say motion to reopen because I can execute the order while motion to reopen is pending, because because remember the person has 90 days. Some people say, oh, instead of appealing, I'm just gonna file a motion to reopen because I have new evidence. Don't do that. Just file an appeal with those new evidence. It's gonna be deemed motion to remand, and then they're gonna bring it back. But the evidence really has to be new, not easily discoverable, wasn't available at the time of the trial. The standard is very high for that. Okay, well, we talked about a lot of subjects in this video because we promised to do long-term type of content. But if you need a consultation, because this time we're living in, it's really overwhelming, okay? And things are not going as planned. Sometimes you really just need to hear from somebody else, especially somebody who has done it before, successfully, of course. Just schedule consultation, okay? Schedule it for your friend, for your family member, for your enemy. But anyway, schedule it so we can help out. We hope that we can give you some type of clarity for what you're really looking for. We're here to help. That's our job. We get paid for it. That's why we have to do it the way we're supposed to be doing it, okay? Until next time, bye-bye.